On Wednesday, the court handed down 86-836, Hazelwood School District v. Kuhlmeier. In a 5-3 ruling, the court said public school officials can determine the content of school newspapers and other activities. In 1983, the case involved 2 articles written for a St. Louis suburban high school newspaper. The principal censored the articles, and the subsequent case dealt with the First Amendment rights of the students. The case was argued in the Supreme Court October 13, 1987. On that week's edition of Supreme Court Review, Barbara Vobeda of the Washington Post summed up the oral argument.
Well, the oral argument centered not on some of the issues which one would have predicted going in. I would have thought, and I expected them to argue about whether the newspaper was a public forum or not. Instead, the justices seemed to focus in on some other questions, and the attorneys argued on some other questions. Robert Bain, who's the attorney for the school board, focused on the question of this newspaper as a product of the curriculum. It is produced by a journalism class. Because it's a part of the curriculum, he argued the principal should have as much control over that as he does over what is taught in a history class, for example. And he said that the principal then was just exercising his editorial discretion, really, and making sure that the newspaper didn't produce things that were distasteful, that violated the privacy rights of some of the students who were talked about in the newspaper. The attorney for the 3 girls who filed the suit, Leslie Edwards, she argued that because this was the principal who had exercised the censorship, it was indeed a violation. If it had been the faculty advisor who teaches the journalism class, for example, it may not have been a violation, because in that case it would be much like an editor at a commercial newspaper who was just paying attention to editorial questions of good taste. But because the newspaper because the censorship was exercised by someone outside that journalistic process, it violated the students' rights.
Were you able to pick up any tone in the terms of the give and take between the justices and the attorneys? Was it were the justices leading them with questions? Were they trying to put them in a certain place, or were the questions fairly open-ended?
Well, they were open-ended, but there was definitely a tone in the arguments. Chief Justice Rehnquist and Justice Scalia both pursued the argument of how far, the extent of control that a school has over the newspaper. Scalia saying, gee, you really leave us in a terrible position. Either there's no newspaper or we have a newspaper that says smoking pot is fun. And that became a standard, which then the justices bantered back and forth. Justice White asks, must then the school require that the newspaper publish a story that says smoking pot is not fun if there is one that says smoking pot is fun? So there was this lively back and forth using that as a standard, and Rehnquist and Scalia pushing both attorneys to say, how much control does a principal really have? Can the principal, for example, stop an issue of the newspaper just because it's full of misspellings? Or can he stop it just because it's in bad taste? So indeed, they were pushing them towards setting some sort of standard for the extent of control.